But we got to talk about one of our main trials of the day, and that is the Stanley Liggins case. But I'm not going to talk about it by myself because I have a very special guest joining me right now. Former prosecutor and also constitutional lawyer, KrisAnne Hall. KrisAnne, welcome here to Law and Crime.
Thank you so much. I'm so excited to be here in studio.
I'm glad that you're here in studio. Now, I could talk about the baby, I could talk about the manure, but I want to talk about good topics.
I know, right?
I was thinking tough SH, but I'm not going to say it. KrisAnne, my question to you, let's talk about Liggins. There is something strange here, and you're a constitutional law expert, about a guy who's on trial 3 times.
Yeah.
Is that rare?
It is not common, and I think probably it happens more than it ought to. There's a principle in our principles of due process about trying the same person more than once. And this double jeopardy thing, I think, has been stretched beyond its intended beginnings. You know, if you have a person that has been tried once and it's been appealed, overturned, tried twice, appealed and overturned, there should be a time and process, even in the conscience of the people, that says, hey, wait a minute, we can't keep doing this over and over again. I mean, not just simply for the defendant, but for the family that have to relive this over and over again. It just seems shocking to the sensibilities.
Yeah, well, this is the first time we've ever covered anything like this on Law and Crime, and we are going to be live in that courtroom. I want to start by playing you the testimony of Mary Ann Watson. This is a neighbor of young Jennifer, one of the last people to see her alive. Let's see what she had to say. Such an eerie and strange case, talking about an event that happened almost 30 years ago. Now, my question is, how tough is it to try a case that's so old? I mean, I know that we have witnesses who are unavailable. That's why their transcript is being read in court. But the physical evidence aspect of it has to be a challenge for prosecution.
Oh, absolutely. I mean, not only physical evidence, but testimonial evidence. You know, and it's not very credible to have a witness reading testimony before a jury. And the problem is because what you have now is something that is detached from emotion. And this is obviously a very emotional case, which would have played heavily in a first trial kind of situation.
But just because he was convicted in the 2 previous cases, which happened back in the 90s, doesn't necessarily mean that he could be convicted a 3rd time in 2018, right?
Well, that's true. And the problem that we see here is that the evidence was withheld from the defense. That's why we're seeing this case over and over again. And you have to wonder, why would the prosecution be withholding exculpatory evidence?
And whether or not that will sway jurors one way or another. It's been an interesting case to follow. We are going to be live in that courtroom, but as I said at the top of the program, that is not the only case that we're going to be live in, because we are also going to be live in the Brett Kavanaugh Senate confirmation hearing for him to become an Associate Justice of the Supreme Court. A lot at stake for Mr. Kavanaugh and also the country as well. And we have a lot to discuss there, but we are going to be live there and Liggins, so you don't want to miss anything here on Law and Crime. We have a very busy day. I'll take a quick break. Wow. Imagine putting out the fire, the burned remains of this 9-year-old girl, having to recount something that happened almost 30 years ago. Pretty incredible and a very strange situation. You know, KrisAnne, I'm listening to this, and we talked about it a little bit earlier. You would think a strong case for the prosecution. They've won 2 times. They secured 2 convictions against this guy. Unfortunately for them, they were overturned because of different issues, which we'll get into in a little bit. But the defense maybe has an advantage here, don't they? Because this 3rd time is very different than those first 2 trials.
Yeah, absolutely. The reason the cases that were overturned to begin with is because the court found that there were a large number of documents and evidence that were not turned over to the defense.
But how important is that for their case? I mean, we're talking about documents, we're talking about Kavanaugh also. How important is it for the jury's ultimate determination of guilt or innocence?
Well, some of this evidence is very important because we're talking about transcripts of a key witness. We're talking about a recorded conversation with a key witness that was never turned over. And so now what we have is an advantage to the defense to have testimony that they can actually use to impeach the witness or to bring credibility question against this witness.
Call me naive, but I always assume that every attorney is doing the right thing, or I'd like to think so. You're a former prosecutor. How on earth would the prosecution have kept this evidence from the defense? How does that happen?
You know, that is a really good question. How does it happen? You want to think that there's an ethical drive. When I was a prosecutor and training prosecutors, I always told them that there's a higher standard for us because we're dealing with people's lives. This is not a case. This is not a court number. This is someone's life. So we have to be very, very careful to not do things outside of ethical boundaries. But I think there's a drive sometimes, especially in cases with children, that we've got to get a bad guy no matter what.
And I understand that, but I'm sure they're not happy having to try this for 3 times. I want to start now with the testimony of Don Schaefer, who is the lead investigator in this case. Now, ladies and gentlemen, this is so important. This is when we start to hear how the physical evidence is attached to the defendant. Take a look. Pretty incredible stuff, listening to the physical evidence, listening about the physical evidence that is attaching to the defendant. KrisAnne, how impactful is that for the jury? Because we've heard a lot of testimony so far, but to hear about the physical evidence, how is that, what are they thinking about right now?
You know, I think that's probably the strongest point of the prosecutor's case this time around, because you're not going to have the emotional impact of the testimony coming forward from the witnesses. But, you know, for me, having to see the pictures again of where the body was and the burned body is very emotional, and to then recount in your mind, this is a 9-year-old girl, and I think of anything that the prosecution has, this has got to be the strongest point for them.
The brutality and the horrific nature of the crime is not in question. The question is, what physical evidence is attached to the defendant here? What you've seen so far, is it DNA? Is it something about his location? We know he was around the victim at the time. We heard a lot of testimony about that. But what do we have physically that ties that man, you see him right there, to Jennifer Ann Lewis?
You know, that's the problem with this case, and especially with the evidence coming forward that was withheld to begin with. This is all very circumstantial. There's no DNA evidence. There's no physical evidence linking him to this crime. And so that's why this time around it may be a little bit different for the prosecution and the verdict.
It's not just a strangulation, they're claiming rape as well.
Right.
That's a big thing to claim.
Yeah, it is. Well, back in 1990, you know, we didn't have the technology that we have now, and the procedure's a lot different, and now that evidence is gone.
Wow, it's incredible. That's why these cases are so fascinating to listen about. I mean, so many times we cover here on Law and Crime those cold cases that are finally reopened, and we get a suspect, the Golden State Killer, you know, the Timothy Coggins case. Fascinating. This is a little different. They keep saying that he's the person who did it. It's just we're going to try him a 3rd time, almost 30 years later. We'll take a quick break. We'll be right back. Stay tuned here on Law and Crime. All right, we're going to jump out right now because there's a lot to discuss before it really gets heated up. Again, I'm here with KrisAnne Hall, but I also have another special guest with me right now, former federal prosecutor Gene Rossi. Gene, great to have you here on Law and Crime.
Thanks for having me.
Gene, I'm going to start with you. We haven't had a chance to speak, and I'm going to get right into it. I know you have very strong opinions about this nominee. My question to you is, what is your main issue with him as a potential Supreme Court justice?
Okay, timing's my biggest concern. When you are considering a Supreme Court justice, you have to look at 3 things. You have to look at their CV, their resume, you have to look at their integrity, and you have to look at their judgment. I think we should spend a little more time looking at the 100,000 documents that haven't been turned over, perusing his record a little bit more, taking a thoughtful approach to a very serious decision.
Okay, I want to stop you right there. The idea that all these documents that they haven't had a chance to review, they have all of his opinions. Do you realistically think that even if they had all of these documents, it's going to change the Democratic opinion one way or another on how they're going to vote?
It may change the Republican opinion. Here's one good example. In 2006 or 2007, you can make a strong argument. I was a prosecutor with the Justice Department for almost 30 years. I know when somebody is misleading or lying under oath. And if you go back and play his testimony from 2006 or 7 before the Senate Judiciary Committee, he made the bold, categorical statement that he had no involvement in the torture decisions, That is a huge deal. And I can't believe this. He is a double Yaley. When he was in the White House working for President Bush and also the right-hand man of Karl Rove, he was the smartest dude in the White House. It is beyond belief that the White House counsel's office would not consult with the smartest guy in the building. Here's my punchline. I think he was involved in a torture decision. I think he was given advice on a torture decision. And the reason they're holding back those 100,000 documents is there are red flags and loud gongs that suggest that he was involved. What does that say about his confirmation?
Just to make sure I get this, you are saying that this man right here lied under oath.
And at best, misleading testimony. And you know who agrees with me? The senators who heard his answer. They made a reference, a referral to the U.S. Department of Justice. And this is the irony.
Gene, we are going to take a quick break, but I do not want to let this go because I want to ask more about this.
Let it go.
We'll be right back. Stay tuned here on Law and Crime. Back to Law and Crime, everybody. Exciting day here on the network. We're talking about the confirmation hearing of Brett Kavanaugh. And right before we left, I have to jump back. I have two special guests here, KrisAnne Hall and Gene Rossi. Gene, you made a very big statement. You said that in 2006, and correct me if I'm wrong, 2006, Brett Kavanaugh misled or lied under oath when he was being confirmed for the D.C. Circuit. Correct me if I'm wrong, if that's what your statement was.
Absolutely.
Absolutely.
And
do you think he should be prosecuted? Do you think this is something that could end up that way?
He can't be prosecuted because the statute of limitations is 5 years.
Let's say there was no statute of limitations.
That's an important point, though. I don't think he should be prosecuted now, but he should not get a pass for making the misleading statements on. We're not talking about having a relationship with a young lady who's in her 20s, President Clinton. We're talking about torture, an issue that involved the Constitution of the United States, something that senators like the late Senator John McCain were very passionate about. And when he testified before the Senate Judiciary, he knew that that was a seminal, explosive issue. And go back and play that testimony. Your jaw drops. He could have said easily, and it wouldn't have bothered me at all. If I were a U.S. Senator, I would have approved him. I was involved in torture decisions. I gave advice, but I thought I was within the law. He didn't say that. He said no involvement.
Okay.
That was misleading.
Oh, interesting, interesting. Okay, we have to jump back to the hearing. Okay, the questioning begins, and this is what we've been waiting for. I want to start off my questioning right now with KrisAnne Hall. You hear so much about precedent, where he's like, the proper justice needs to follow precedent. Do you agree with that?
Well, I think that it's a principle that has been misapplied too much over the years. We have to follow precedent, but it's not about creating precedent as the rule of law. It's about making sure that the precedent complies first with the Constitution. So there is no obligation to follow that precedent if that precedent then contradicts or does not go with the Constitution. I'll take, for example, Dred Scott, which was obviously not a constitutionally based Supreme Court case.
Do you think that he is too narrow in his interpretation of that you have to follow precedent, you can't adapt?
Oh, absolutely.
So that's your criticism of Kavanaugh?
Yeah, that would be one of my criticisms of Kavanaugh. His statement that as a district court judge he has to follow Supreme Court precedent is simply not true, because every single justice takes an oath first to the Constitution of the United States. And it is the judicial process of due process that requires the judges to question and hold these opinions up to the Constitution as the standard.
Okay, but I'm here also with Gene Rossi, and Gene,
yes,
he says he's going to be independent. He says he's a team player. He says he's not going to let his personal predilections influence his decisions. What do you think about that? Because that's a common statement from every justice that's ever served, that they will be independent.
Well, first thing I have to say is he went through about 12 murder boards, and he's doing a fantastic job in presenting his case, if you will. Looking at the audience, he's got his thoughts clear, polished as you can believe. So I give him an A+, and I'm sure Professor Hall would give him an A+ too.
Right.
I agree with her. You can't be so rigid. Rigidity when you're looking at precedent is not a good quality in my view. And we were just talking before, what about Korematsu? What about Plessy? Okay, Brown versus Board of Education would never have been decided the way it was if precedent were your North Star. So I agree with the professor, my fellow professor, that you can't be wedded to precedent, and he seems a little bit wedded.
Okay, we're going to talk about that, but when we get back, I want to talk about him saying he's going to be independent, because that's a real big issue. So we're going to take a quick break. When we come back, we'll be live. Stay tuned here on Law and Crime. And the questioning has begun. Gun rights and Roe v. Wade. We're not wasting any time, and we're not going to waste any time here. I want to start with Eugene.
Yes.
He just said that he's going to follow precedent, that he realistically can't change things, and no matter what.
Yeah.
So talking about Roe v. Wade here,
right.
How can he realistically, and all the criticisms against him, if a case like that comes up, how can he realistically change abortion rights in this country? Is that even possible?
Yes, it is.
How?
First off, I'm strongly pro-choice, and here's how a justice and circuit judges at the federal level can chisel and chip away at the right to choose. Every opinion over the last 20 years that hit the Supreme Court, there have been issues about reasonable limitations on access to abortion. Okay? One of them was Garza, which hit the D.C. Circuit, and Justice Kavanaugh wrote a blazing dissent about an undocumented person who was trying to get an abortion before 20 weeks. She got approved by Texas state officials. But your question is very important. They won't overturn Roe v. Wade. They won't. But what they could do in the next 5, 10, 15 years is you will see 5 to 4 decisions, a lot, where we're chipping away at that right, making it harder for a woman to have access and to make that important constitutional decision to have a child or not have a child. Chipping away is the avenue they're not going to overrule.
Okay. KrisAnne, do you agree with that, that there is going to be a chipping away of Roe v. Wade, or is it just not an issue?
You know, I think that speculating on what's going to be happening over the next 5, 10, 15 years is not what we're supposed to be doing here today. We're supposed to be evaluating
We're
Kavanaugh.
not? Isn't that what he's going to be, a lifetime justice?
But we're not. But the court will be also a different court in 5, 10, 15 years. We're talking about this court right now. And this court right now, that's not going to happen. It's not going to be happening where they're going to overturn it. They're not going to. I don't even see the opportunity for them to chip away with the establishment of the court that we have right now. Again, it's not a. It should be a matter of, number one, does this follow the Constitution, and number two, how does this infringe on the rights of the people?
I have to strongly.
Well, Gene, we have to take a break. So you will stand by. Both of you are going to stand by. Respectfully. When we come back, a lot more to discuss. Stay tuned. The questioning continues in the confirmation hearing for Brett Kavanaugh. I want to talk a little bit more about it. KrisAnne Hall, my first question to you is, talked about the criminal investigation of a president. Now, for supporters of Kavanaugh, they could say, hey, listen, he just gave recommendations for Congress. He never ruled on the constitutionality of that issue. What would you say to them?
I would say that Kavanaugh should be clear on the constitutionality of that issue. As the drafters of our Constitution wrote reams and reams about the limited power of the president and why they were creating the office of the president limited. And the chiefest concern during the drafting of our Constitution was, how do we keep this single person, the head of the executive branch, from becoming the king that we just escaped from? And they did that by confining the office of the president in a very defined and limited capacity. And for the people to think that the president cannot be held accountable to the laws of the country, to the laws of the states, is to then elevate the office of the president to be above the law and create the very circumstance that the drafters of the Constitution were attempting to prevent the president from becoming a king.
You're so articulate. I think you should be the next nominee in a little bit. I don't even know what to say after that. Gene, my question to you is, we're talking about the...
I 100% agree with the professor.
Right, Professor. But the qualifications, that's what we're talking about, the qualifications. What would you say to people say, he's a qualified candidate. He served as a judge for 12 years, wrote over 300 opinions. What would you say? Isn't this all about qualifications? It doesn't matter what his views are?
Totally disagree with that. When you look at a candidate, it goes back to what I said in the beginning. You look at 3 things. One, do they have the CV, the resume? Okay, he's a double Yaley. And as I joked to you, the closest I came to Yale is driving through New Haven, okay?
Yeah.
Qualifications, A+. Judgment is also a very important test, and integrity.
Right.
I question those two tests.
Okay.
Not as qualifications.
Well, we're going to talk about those tests when we get back from our break because there's a lot more to talk about. Welcome back, everybody. We have a lot to talk about with the confirmation hearing of Brett Kavanaugh. Gene, I want to start with you.
Yes.
He was asked about what you and I talked about at the top of the program,
right.
about where you said he misled Congress in 2006 about his involvement in those interrogation policies of the Bush administration. He was asked about it point blank right there, and he said, look, I told the truth then, I told the truth now. Are you saying right now that he's still not telling the truth?
Absolutely, and I'll tell you why. I'm sitting next to a former prosecutor. I've seen witnesses get on a stand and dig in on a prior statement. And what he's doing is digging in. Here's why. And I would love to cross-examine him. He said after 9/11, things changed in his mind and he cared deeply about all these issues, national security, right to an attorney, things like that. I cannot believe that Karl Rove Gopher, the smartest guy in the White House, was not consulted about the torture issue. There is absolutely no way, and it goes back to the 100,000 documents that they haven't turned over, where they, in my view, unjustly invoked attorney-client privilege, deliberative process, and executive privilege for his memos that they turned over with Justice Roberts. There are memos, there's no doubt in my mind, in the White House, among staff, or including him, where he's talking about the torture issue. I just want to end with this.
Yeah.
He says I wasn't read in to that issue. First off, what does that mean? You know what it means? It's polenta. Polenta is the Italian answer to Southern grits. I'm Italian, I can say this. Polenta is boring. You have to serve it with something else. He is engaging in verbal polenta.
I might have to use that. I like that a lot.
I like it a lot.
Do you agree with that? That what's really the issue is what's kept in those records that haven't been made available to the senators is this information about his involvement in the Bush administration's interrogation policies, or is there something else that you feel that they're not showing? Because again, we have all of his opinions. What else do we need in order to confirm him?
Well, you know, I think that at this point it's probably just speculation. We can't know what we don't know. But here's the point that I want to make. We are not supposed to be rubber stamping a presidential nomination. We have a check and balance process. That's why the Senate is involved in this. The hearing is essential in discerning whether we have a real person who is suitable for the bench. And so we have to realize that this is a process. And if Kavanaugh is not selected, then the president has to nominate someone else. This is not the be-all, end-all. I believe that Kavanaugh will be actually confirmed at the end. But this is an important process.
What a process it is. KrisAnne Hall, Gene Rossi, thank you so much both for coming on and talking about this.
Thank you so much.
We have to take a quick break. We'll be right back.